Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast. I'm your host, Spencer Karen. On April 28, 2021, the Supreme Court heard oral argument in Mahanoy Area School District versus BL. The question before the court was whether Tinker versus Des Moines Independent Community School District, which holds that public school officials may regulate speech that would materially and substantially disrupt the work and discipline of the school, applies to student speech that occurs off campus. Michael Dimino, Professor of Law at Widener University Commonwealth Law School, joins us today to discuss this case's oral argument.
This is a particularly fun case to talk about. When I teach First Amendment in law school, the students often really enjoy the opportunity to discuss the constitutional principles that are applicable to students' speech. And the Supreme Court has not heard too many cases on the subject. There have been 4. This would be the 5th. And this case presents a new twist. The question of the case is, to what extent can schools regulate off-campus speech that has an effect, perhaps a disruptive effect, in school? Can schools discipline students for off-campus speech? The court has never addressed this question before. All of its other cases have dealt either with on-campus speech or with speech occurring in a school-supervised function. Perhaps you remember the Bong Hits for Jesus case, Morse versus Frederick, that involved an activity outside the school building, but in a school-sanctioned field trip. This case, however, involves student speech that is entirely off school grounds, entirely outside school hours. The student made a social media post that is the subject of this discipline. The student in question, BL, was a sophomore at the Mahanoy School District's high school. She was a cheerleader. She had tried out for the cheerleading squad as a freshman and made the JV team. She tried out again as a sophomore and made the JV team again, contrary to her desire to make the varsity team. She was frustrated about that. She was frustrated with what she perceived as more favorable treatment given to other students. She was frustrated with her softball team, which was not affiliated with the school, but just a recreational softball team. She was frustrated with the school in general and with her coaches, etc. So she posted on Snapchat a profane rant that used the F word several times in a long string of F cheer, F softball, F school, F everything. The Snapchat was seen by several of her classmates, some of whom brought it to the cheerleading coaches' attention. Those coaches addressed the matter with BL, and ultimately she was suspended from the cheerleading squad for an entire year. Said she could try out again the next year, but she'd be off the cheerleading squad for that entire year because of what was perceived as her disrespectful and profane post. In the school district's view, the post demeaned the school and the coaches and undermined the position of the school, undermined the attitude that the public might have of the school, called that into some question. And so the cheerleading squad thought that some discipline was in order. That was the discipline they agreed on. The student and her parents appealed through the school's processes, but the suspension was affirmed by the principal and the superintendent, the Board of Education, and so on. So then there's a lawsuit. She sues in the Middle District of Pennsylvania, alleging that the discipline for her off-campus speech violated the First Amendment. The district court agreed. The Third Circuit also agreed, but the school district sought certiorari from the U.S. Supreme Court, and cert was granted. And that's the case that was heard today. The dispute between the various contending parties, the school district on the one hand, BL on the other hand, and the Solicitor General also had a piece of the oral argument supporting the school district. The debate between the varying positions in the oral argument boiled down to an attempt to create an administrable rule. The justices expressed considerable dissatisfaction about the proposed rules from both sides and wondered whether all the proposals were so vague as to amount to a rule that would not be capable of clear administration. Neither side, however, wanted to create such a clear rule that it would interfere with some policy desires that would push in the other direction. So, for example, the school district did not want a rule that said, did not argue for a rule that says we can discipline students as long as they're students in our school. We can discipline them for their speech whenever we think it's appropriate. We can't, the school district didn't want, for example, to be able to impose a general good conduct rule on students for all their speech, whether on campus or off, regardless of what topic it addressed. Instead, the school argued for this position. The school said, we want to be able to discipline students' speech if it is directed to a school audience and on a school topic. And because this Snapchat post referred to the school and was visible by and indeed viewed by the other students on the cheerleading squad, that this, according to the school district, qualified as speech to a school audience on a school topic. And having concluded that, court says, or the school district said, that we should be able to discipline the student for the speech so long as it causes or threatens to cause a substantial disruption, taking that language about a disruption in the school from the Supreme Court's major precedent in this field, Tinker versus Des Moines Area School District. In that case, the Supreme Court had upheld a student's right to protest the Vietnam War by wearing a black armband to class. And the court said that there doesn't seem to be much of a disruption caused by the wearing of that black armband, and absent a substantial disruption or an interference with the rights of other students, there wasn't any justification for the school district to interfere with that student's right to express his views on the Vietnam War. According to the school district, it would be wrong to create a clear rule between on-campus and off-campus speech, like the Third Circuit did in this case. The clear rule would say something like this, that the school district can regulate students' conduct, including student speech, while the student is at school. But when the student's not at school, then the school would have to treat that student the same as the rest of the government would have to treat the student. That is, the student would have a right to engage in free speech the same as every other citizen, except when the student is in school, and then the student would be subject to more limitations on his or her speech. The school district did not want that rule because the school district said the whole point of allowing schools to regulate student speech is that the student speech causes a disruption in the school. The reason that we don't allow someone to have a political protest in the middle of math class is because it interferes with the ability of the school to teach the math lesson. And the school says, you can cause that kind of disruption even if you make the speech off campus or outside of school hours, if it causes such an uproar in the school that it distracts the students from the lessons or makes it difficult or impossible for the teachers to carry out the educational mission of the school. So, in the view of the school district, the key should be, what is the effect on the school? Is the speech causing a material and substantial disruption with the school? Don't focus, says the school district, on when or where the speech was made. Focus on the effect on the school. BL, by contrast, argued for what seemed like a very different rule, although the justices probed as to whether it was all that significant a difference in practice. The students' proposed rule was instead that the question should be whether there is a school-supervised activity. According to the student, the Tinker test, material and substantial disruption with the school environment, should apply for any school-supervised activity. So most of those would occur on school grounds. They could include classes, they could include homeroom, they could include lunch periods, they could include an on-campus recess, or athletic teams, field trips, those sorts of things. Anything that is school supervised would be subject to Tinker's material and substantial disruption test. However, for other kinds of activities, speech that is not subject to school supervision when it was made, in regulating that kind of speech, the court said that the school district should be in exactly the same position that the rest of government should be in when it's acting as a sovereign. And so if the rest of government, if the legislature and the courts or some agency could not discipline someone for certain insulting speech, then the school district should not be able to impose discipline for insulting speech simply because the student happens to be enrolled at a school when the speech occurs outside of any kind of school-sponsored activity. According to the students' argument, the contrary rule, a rule that would allow the school to impose discipline based on speech that occurs outside of a school-sponsored activity, that rule would allow the school to control the student's speech constantly. As David Cole, the counsel for the student, said, that kind of rule favored by the school district would force the kids to carry schools on their backs constantly, that the students, no matter where they were speaking, could always feel the need to conform to the school's desired code of speech, which Mr. Cole argued was dangerous to principles of free speech. It would as he argued, the Tinker rule that allows for school districts to impose some limitation on student speech where it would cause a material and substantial interference with the educational mission. Cole says that was designed to be and is supposed to be a small exception to a general principle. It allows the school districts to regulate speech in a small amount of situations where there is that material and substantial disruption in the school environment caused by things like a protest in the middle of math class. Cole says, if you change that to a rule that allows the school district to regulate speech anytime the speech occurs, so long as there is a disruption in the school, then he says, you're taking what was supposed to be a small exception and making it the rule. That then the schools will be able to regulate student speech all the time, because in this internet age, the social media age, the way that students speak is through social media, and the effect of social media could easily produce some kind of disruption in the school environment. And so a rule that would allow the school to discipline students based on the possibility of a disruption in school would allow the schools to discipline students for pretty much all student speech that the school district believes threatens that standard. Further, a major issue that was discussed by the parties and the justices seems to have been the thing that Chief Justice Roberts focused on more than any other topic, was the concern about the effect on students' speech on we might call important topics, First Amendment preferred topics, things like politics, morality, religion, that kind of thing. In the view of the student, it was necessary to create the kind of test that the student proposed, because if a material and substantial disruption would be enough to allow a school to punish a student's speech, well, then the student could be punished based on that student's political statements off campus, outside of school hours, if enough people in the school disagreed. If enough people in the school disagreed, then you'd produce a disruption in school, and someone could be disciplined by saying Black Lives Matter or Blue Lives Matter, or I'm pro-choice, or I'm anti-abortion, or whatever it is. And the justices seemed pretty concerned that any kind of standard must protect that kind of political speech. Now, not even the school district said that it wanted the authority to do quite that. Lisa Blatt for the school district argued that the last thing that the school district wanted to create was a rule of a heckler's veto. And so even the school district said that politics, disputes on politics should not be cause for school discipline. In particular, she argued that the schools should be able to discipline students for speech that causes a material and substantial disruption, but, she said, the disruption must be more than just other students taking offense. There must be some reason to fear a disruption that is more than that. So I think the important thing for you all to understand from this oral argument is that the positions of the parties are probably not as far apart as you might have assumed them to be when you heard what the case is about. So the school district is not arguing for full authority to discipline students for any speech at any time. The student is not arguing to be able to say whatever she wants as long as she is outside the school walls. The proposed tests on both sides are a little more nuanced than that. The problem that the justices focused on for most of the oral argument was the difficulty in creating a test that would appropriately distinguish between the kinds of speech off campus that would be subject properly to discipline and the ones that would not. And the justices, as they often do, proposed a series of hypotheticals to the contending lawyers. And they asked, for example, about bullying. Suppose that a bunch of students insult another student, not in a way that would be so severe as to amount to a threat, nothing that would be obscene, nothing that would amount to a category of unprotected speech. But if it occurs off school grounds, would the school be powerless to do anything about it? And the school district's answer, of course, to that is no, that they should be able to deal with that if the speech was targeted at a school audience, another student, and caused a material and substantial disruption in the school. The students' argument was that bullying could be the subject of discipline by the school district, but only on fairly strict conditions. If the particular speech was constitutionally unprotected, if it amounted to a true threat, for example, then it could be disciplined, of course. In addition, Mr. Cole suggested that it would be possible to create a bullying policy that, if defined clearly enough, and if limited to severe and pervasive harassment, kind of standard that applies to sexual harassment in the workplace, that if the anti-bullying rule were defined clearly enough, that it would be constitutional, he said, to apply an anti-bullying rule to allow schools to enforce some discipline to students for off-campus speech that occurred without any kind of school supervised activity. We saw a considerable divergence of opinion among the justices based on their preference for rules over standards, case-by-case adjudication versus clear rules. Justice Breyer repeatedly suggested that coming up with a clear rule in this case might be difficult, might be inadvisable, and so perhaps a very narrow rule might be better. And there are a couple of possible narrow rules. The court suggested that maybe the court could rule in favor of the school district by saying that just because the speech occurs off campus doesn't necessarily mean that the schools can't regulate it, and then the court could remand for further proceedings on that understanding of Tinker. On the other hand, many of the justices seemed to agree that this discipline in this case was quite an overreaction by the school, that the Snapchat post that this student created was juvenile, it was profane, it was somewhat insulting, but it wasn't a big enough deal to cause a reasonable person to think that a 1-year suspension would be appropriate. And it didn't do anything to cause all that much of a disruption in school, except that the rest of the cheerleading squad said, "Oh, did you see what BL posted?" And the justices seemed to suggest that this just isn't the school district did not have a justification for imposing discipline on her. So there seems to be some appetite on the court for not making this case quite the big case that it could be, and that some of us were hoping that it could be. The court could decide the case narrowly in favor of the school district or narrowly in favor of the student. And if it decided it narrowly in favor of the student, the court would just say that even if the Tinker standard applies, there wasn't a reasonable belief that this post would lead to a material and substantial interference with the educational processes of the school. And so the student should win the lawsuit without establishing a clear standard that would govern future cases. Some other justices, though, perhaps most notably Justice Alito, who mentioned this a couple of times, said that if we are going to come up with a standard, the standard should be clear, particularly when we're creating a standard about the regulation of speech. There's a tremendous value in creating a standard that is administrable. And so he probed some of the lawyers a couple of different times on the need to create a clear standard, and talked about whether it would be possible to create a standard that would protect students' speech, particularly the ability of students to discuss politics, religion, and the like, without worrying about conforming to a school's speech code. And those of you who are familiar enough with this area to have read his separate opinion in Morse versus Frederick would not be surprised by the attitude that he took there, the need for clear rules and the need to protect students' ability to discuss political and other meaningful topics. Kavanaugh was kind of on the other end of that focus. He kept coming back to the particulars of this case and suggested that BL was just blowing off steam, that she was acting the same way that thousands of others acted upon getting kind of disappointment about not making the team that you were trying out for. And he suggested that even if the First Amendment might not be directly pertinent to the question of the legality of this punishment, that there was still something deeply troubling to him about the draconian 1-year suspension for BL's post that was perhaps intemperate, perhaps ill-advised, but in his view, not all that big a deal and not all that unusual. All of the justices, though, did seem to understand that that the internet age, the social media age, did require a rethinking of what the proper limits on school speech should be. They were just not clear on what direction that pushes. So on the side of the student, the argument is that because so much student speech, so much young people's speech occurs on social media, that we should be careful to create a rule that doesn't allow schools to censor what amounts to just about all of students' public speech. On the other hand, some of the more liberal justices, Sotomayor and Kagan in particular, talked about this theme, and certainly the lawyer for the school district did, that the social media age means that students' speech off campus is more likely to have an effect on the school than in the past. That the pure geographic line, schools can regulate speech on school grounds, but they can't off school grounds, doesn't make a lot of sense from the point of view that schools should be able to allow, to regulate speech that interferes with the school's educational process. As those justices and Ms. Blatt pointed out, that just doesn't doesn't match up with the what the effect is going to be on the school. That is, off-campus speech can have just as much of a distracting effect on schools as speech that occurs on the school ground. The court heard argument today in late April. A decision is expected by late June, so a couple of months from now. And I think if I had to give a prediction, I think it's reasonably likely that at least more. If I had to give a prediction, I would say more than a 50% chance that the student wins at least some. As to what the standard will be, I don't know, but it seems like very few of the justices think that discipline, at least this 1-year discipline, is appropriate for BL. If the school district does win, therefore, it's not likely to be an outright reversal of the Third Circuit. It seems like the best that the school district has, the best possibility the school district has is a reversal and a remand with instructions to allow the school district to demonstrate that her BL's post did have or was threatening to have a substantial disruptive effect on the school, and only then, if the school made out that standard, would it be able to impose the discipline. So ultimately, I'm not sure that the school district has much chance to impose the discipline on her, but I'm not sure what standard is going to result from the case. This could be anywhere from a blockbuster that could be the second most important case next on school speech next to Tinker, or it could be a case that is self-consciously designed not to create a rule, and that is just leaves further development to another day.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.